No voices, good. Anybody from plenary who wants to raise an issue with anything Dr. Hageman's group covered? Okay, that was easy. Yeah. Okay, now adoption. Do we need to vote or? No, okay. Sorry, I'm new at this. Can we adopt the report, Commission 1's report? Everybody happy? I don't see any hands, no complaints, no suggestions. Report adopted. Right. Time-wise, we've got Commission 4. The chair, please. Commission 4's Advocate Skusana will be presenting the review of the criminal justice legislation and considerations for the correctional system. Over to you. Sorry.
There you go. Thank you, Program Director. Let me acknowledge the Honorable Minister, Honorable Deputy Minister, National Commissioner, judges, and all participants in terms of their protocols. I'm going to present the deliberations in Commission 4, and I'll try to be as quick as I can so that if colleagues from the Commission want to add, they've got also time to do so. I must start by saying that, I'm from the Southern Law Reform Commission. I'm a commissioner after I've spent quite some decades, 3 decades in the Department of Justice, head of policy and also a senior manager. And thank you, National Commissioner and the Minister for the invitation. And I've also brought here the greetings from the Commission, led by Justice Chris Jafta as the chairperson. There are quite a number of slides, but I'm only going to target the last 4 slides. And I'm going to start by saying, yesterday, when I was seated here during the deliberations, I started making notes on the amendments that need to be taken forward from yesterday's deliberations, even before the commissions. And today, I will basically added to what I started yesterday, so that can basically give a full spectrum of what may happen. But I wanted to indicate that our commission also will also take into account some of the other legislative reforms from the other commissions, so that there's a consolidated process of all the legislative reforms that need to go into this process, and also provide some form of consolidation of those views. We are very fortunate to have Justice Cameron in our commission, as well as quite a number of eminent persons who are very well informed about the operation of the parole system. I want to start before the judges. I want to start with I've seen yesterday they started presenting the quotations. Marlise said, if you want to go fast, go alone. If you want to go further, go together. And there was also someone who said the criminals are every society deserves the criminals. That's the budgets. Now I want to start with a real scenario of recidivism, which happened in my space when I was a prosecutor. The magistrate asked the accused, there was a conversation between the 2 people, which I observed. Magistrates asked the accused, why are you here today? In the past 10 years, you have appeared before me more than 4 times. Then the accused says to the magistrate, yes, through the interpreter, yes, my worship. And this is what I've been telling the police, that you don't want to see me again, but they never want to listen. They brought me here. Right? Slide number, yes. Can you go back? I want to start back. Yes, these are the recommendations that started from yesterday. Obviously, there was a lot of debates around the whole issue of Section 276A and 286, which need reform. And these are old legislations. They come a long way from 1993. just before the Makwanyane judgment, which set up the tone for the reform of the system and brought all elements of Ubuntu into our system, etc. So the reform of this act, of these provisions is very long overdue, and I think the Commission have already started to engage with those processes, and I think the contributions and the inputs, they were very informative towards that process. The terms of reference of the CPA reform was that we need to look into the other legislation which basically have impact on the entire criminal justice value chain. It was not only the CPA. So the reform of the Criminal Justice Act, Correctional Service Act, the reform of the Minimum Sentencing Act, SAPS Act, etc., should basically form part of this process insofar as those acts relate to criminal justice system, etc. And obviously, from the contribution yesterday from the chairperson of the Human Rights Commission, he mentioned the whole notion of the transparency in the parole system as a mechanism to ensure community participation in the rehabilitation process, etc. If people know how that these are the people who have been given parole system, they'll assist DCS in terms of being a watchdog over the person, but assisting the persons. And as of now, those issues are missing in the Act. Next slide. Nature of punishment. If you go to court today, you all know that you are going to get one sentence, either fine with an option, a prison term with an option of a fine, or a suspended sentence. We still need to hone in or hammer the new sentencing regime that include within it the community sentencing processes, so that you don't only bring the community service as part of the parole, it becomes emitted out as part of the sentence right at the beginning. And those basically entails the overarching reform of the Correctional Service Act as well as the CPA. And the question that we are asking ourselves, the Commission, is whether DCS will have the capacity to manage those community sentencing in terms of oversight, in terms of monitoring, or we need to create a robust and a civil society approach that should take care of those processes, etc. Part of the proposal that came from the Commission more than 20 years ago is the need to include a reparation. I heard yesterday people saying that you go to court, people have burned your house, they get sentenced, the money goes and go into a fiscus. I get nothing. I spent 5 days in the witness box, I've been grilled, etc. Then they say, thank you, you may go home. They remain behind in the court, they pass each other sentences, I'm at home, they pay each other. Nobody speaks to me, nobody comes to me, etc. My house remains bent down. You come with reparation, you will basically include how the complaint can be restituted into a position that basically ameliorate his or her position, etc. Those sentences are not part of our regime. Ironically, the 1955 CPA included restitution. The 1977 CPA excluded it. They only put 2 sentences, Section 300 and 297. 300 is very limited. It only provides when can you ask compensation, and Judge Makam has explained the challenges in terms of enforcement. You can get that order. To get it, you must go to an attorney and get a civil processes to execute against that judgment. When the accused have got represented by senior counsel, etc., you must find, for your bent house, you must not find money to get a lawyer to help you claim for reparation of 400,000, which never gets done anyway. Terms of reference, I've already indicated that the terms of reference of the CPA already included parole and correctional supervision. And the debate here today are helping to hold those kind of aspects. Next slide. There was issue of the legal aid. Now, the debate of whether victims need to be represented by legal aid, etc., is a very thorny issue. But the reality is that the government is overstretched. The legal aid is overstretched. We must look at different avenues to help the victims. And part of the avenues is, I've put them there, we must amend the POCA Act to provide for a clear direction to DSD, Department of Social Development, on how they must assist victims. Currently, they're only given the mandate to support NGOs that support victims. So the chain is very too long. They don't have oversight in terms of what the NGO does. They only give them money. And at the end of the day, those people are not accountable to Parliament. They cannot come and indicate how they use the kind of money for. So we need to strengthen those other mechanisms. But also, I gave an example that what we have today in terms of CARA. CARA is the criminal asset recovery register account. When I was in justice, I used to manage that CARA fund. I used to consider submissions. I used to refuse many from DCS. I used to refuse many from NPA, etc. Simply because department used to come and want to use CARA to augment the shortfall of the budget, etc. Not in terms of what the act intended for. But the shortfall about that act is that I put there is based not on a growth investment strategy. It's based on spend and replenish. You get what you have, you get 2 billion, 15 billion, you spend it and hope that tomorrow you'll get other money, etc. And I give example, it's like RAF. Road Accident Fund, we spend and replenish. We spend and replenish. It is unlike PIC. PIC, they have a growth strategy. That's why the funds for pensioners of government will never run dry, because they grow their investment. Now, there are proposals and those proposals were discussed with the late Minister Tito Mbune sometime. Why don't you create a fund that will basically grow the criminal asset register account so that it's not dependent on what they get replenished from, but it's also based on what growth it gets. You cannot have 16 billion, which was recouped from the Gupta's activities, lying in the account, not growing, waiting for the parents to come and claim from it, etc. You must use that money to benefit the system, and these are part of the reforms processes that you can take moving forward. Yesterday, they talked about the whole issue of expungement of records, how the expungement processes hinder people from getting employment. You train them in correctional services, they become experts, they get out, they've got criminal records, they cannot get jobs. They are forced to reoffend because they've got nothing to do. Next slide. Today, those ones were the ones I wrote yesterday, those amendments. Today at the commissions, there were thematic areas that we basically looked at and basically consolidated. There was a unanimous position that we need to ensure alignment of legislative reform processes across all the acts. And that's what we say. You cannot reform and amend CPA without looking into a Correctional Services Act, without looking into subs where it's necessary, when you look at parole, look at all those legislation that pertain to parole so that there's an alignment process across the amendments, but also that alignment process is formed by the same timelines, because other acts will be far away, others will be far behind, and we're going to create a lot of disjuncture in the process, etc. Distinguish between rehabilitation and punishment, and it came very strong in terms of how we need to provide for definition in the acts, so that when people talk about rehabilitation and punishment, etc., it's understood in that context. And I've said, definitions also help the judges and the magistrates to be able to interpret what was the intention of the legislature. You can use whatever words you want to use, but you must understand the words in the context of that act, not in the context of how we use that language in different scenarios, etc. Reform sentencing regime, I've talked about that, and the issue of the minimum sentencing have come many times. And people are asking whether it helped to address the issue of crime, etc., or it has basically created problems for DCS, etc. And those, I think, we're at a stage where we need to review that legislation. I'm glad members of parliament were able to reflect their views on that other point. Look at the minister's powers. I've spoken about the definitions. Really look at the minister's powers of review and the delegation of powers. There are strong views that the delegation dispensation will improve efficiency, will ensure the speed in terms of this process, but will also assist taking over some of the matters which unnecessarily end up in the courts. when those delegations should be with the minister. And that's the method of separation of powers. The courts must end its function by sentencing the persons. What happened beyond the judgment does not belong to the court. We must not trouble them. They have given the judgment. Take over the responsibility. They don't want to see you again. So if you keep bringing matters to your court, you are basically overclocking the court system. Because instead of dealing with new matters, it keeps dealing with matters that come from parole, whatever. We have heard about how Justice Mlambo got so frustrated that he decided to go to the constitutional court because he can't manage a court role in the Gauteng division of the High Court. There has been a clear argument for a separate act on the parole to enhance the independence, ensure efficiency, pull together the resources around that act, and also enhance parliamentary oversight. And I think the issue of parliamentary oversight became very, 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 very critical in the discussion, that if there's no clear articulation in the Act for parliamentary oversight, either in terms of how annual reports should be drafted, in terms of the parole system, whatever, we will get to what we got yesterday. We are not sure what are the correct numbers of the percentage of recidivism in South Africa, etc. And that we bend out all different numbers, etc. But if we got a clear, reliable system in terms of which the department account to Parliament, those will be avoided. Next slide. The issue of non-nationals became very critical, and I was very happy that I never had anyone from the South African Human Rights Commission in the Breakaway Commission. Otherwise, we will be in problems, or somebody from the Legal Resources Center. There will be papers that will be prepared for the court already. Now, the reality is that the issue of crime, the issue of correctional services, it impacts on all people who are convicted by the court, etc. But there are opportunities. And part of the opportunity is that the parole system, if people are eligible for parole, let them go and serve parole at their own country of origin, where there are support systems, where they can be monitored, etc. Rather than release them on parole here and then have them deported by Home Affairs with no system in place. Those people come back and they offend again in terms of that. Moralization of data, inconsistency of the rate of recidivism, I've talked about that, but moralization came in different perspective. It also came in the perspective of IJS. And I think there were very critical perceptions raised that IJS, we need to move beyond all the points we have been at over the past 30 years. There's a need to see the results and the outcomes of moralization in a manner that improve the criminal justice system moving forward. Victim central, it's part of what I'm already dealing with, etc. There are no definition of victims. No, in fact, the whole Criminal Procedure Act, the only time where it speaks about victims is when it speaks about parole. Before then, it calls victims witnesses. So if you have been mauled down in an assault, robbery, whatever, you get called by the prosecutor as a witness, not as a victim. And you are recorded as a witness. After you have given your testimony, the judge said, thank you, sir, you can go home. And that's your case. You leave people behind there, discuss your fate. And tomorrow you see somebody being given suspended sentence or on parole, nobody is going to you because you are a witness. So the moment you get definition in the CPA, they play a critical role in the criminal justice system. Public involvement was emphasized. The whole issue of parole not being used to curb overcrowding. The minister emphasized that yesterday, that don't use parole to address overcrowding processes. Deal with overcrowding as a challenge. Look around the issue of bail. Look around the issue of minimum sentencing. Look around the issues of the awaiting trial prisoners. Because the reality, and I was saying to some of the colleagues yesterday in DCS, and say the correctional centers are overcrowded in a situation where the courts are not effective. Just imagine if the courts were effective, cases were running in the courts. You are getting sentenced every day. Where will you put the people? So this obviously talks to a whole issue of intersectional coordination and integration, etc. Next slide, I'm about to finish. Justice Cameron came with led us to this proposal. I think we're mindful that the time given to us would not have been sufficient to consolidate and zone into thematic areas, even identify explicitly what needs to happen. So the overall approach was that we should then recommend to this plenary that they look at a possibility of coming with a post-summit a process that will bring together a team of experts that will consolidate all the reform initiative, legislative reform initiative from all the breakaway groups, put them into one, align them with the timelines, look into what is doable immediately, what is long-term, etc., and then deal with a proposal that can then be processed through the Minister to Parliament. And those aspects, we believe, can then ensure that the outcomes of today's deliberations are going to take this process forward. I must just say that there will still be a public consultation processes on the CPA. At our breakaway commissions, there was a colleague from POPRO who asked that there still the made submissions in terms of the use of lethal force by the police in arrest and all those things, etc. All those are amendment of Section 49. All those are issues that still need to be engaged with. And as part of this aligned process, it will assist that when the Commission goes into a process of public participation on the other reform processes, which we intend to do by the end of this year, then the process of the parole should be part of that engagement. In that way, you have one integrated and cohesive process of the reform of the legislation, rather than you hear CPA, it goes to Parliament, Minister of Justice present the public hearings, 2 years thereafter, Minister of Social Services come with a parole pack of the CPA, 3 years thereafter, Minister of Social Development comes with another part of the victims, whatever. So there's an opportunity to consolidate and integrate the processes so that when you go out there and speak to the people, when they ask questions, all the ministers, they form one panel. They respond to their own issues in terms of the line of responsibilities. I'm going to stop it here and allow colleagues in the commissions to add to this presentation. Thank you, Madam Chair.
Thank you, Advocate Skosana. Sorry, I'm obviously hungry. I agree with him on this last slide. Totally, the time allotted to us was nothing short of criminal. Whoever's phone that is, please attend to it. Thank you. Thank you. Right. Are there any outstanding matters from members of Commission 4? Nothing. Wow, everybody's towing the line today. Any outstanding matters from plenary on Advocate Skosana's input? Nothing. Sure. You can see tomorrow's a public holiday. Can we adopt the report then? Commission 4? Report adopted. Shall we break for lunch? Okay. We'll be here not a minute later than quarter to 2. And if we are late, we work late. Tomorrow's a holiday, remember? 1:45. All of you. Thank you. And I presume we're eating in the same place as we ate yesterday. Okay. We'll see you later.